We are in the early stages of the Kyle Rittenhouse. One of the first pretrial hearings has occurred, and we're going to discuss what evidence has been determined to be allowed in this trial and what has been disallowed, because I think it speaks volumes to the strength of the case, or lack thereof, that the prosecution actually has. But first, we have a sponsor. I'm just going to transition into it so we can get out of it and talk about the topic. Weight loss gets more and more difficult as we get older. This is because once you hit your 20s, every subsequent decade will slow your metabolism by on average around 4%. And when you hit 50, it's about 10%. That's the reason why age and weight gain are strongly correlated. And it's also why I recommend Keto with Justice. Shortly after using this product, thousands of Americans have reported slimmer stomachs, weight loss, and leaner muscles, and it's the fastest way to burn fat that I know of. I highly recommend going to ketowithjustice.com so that you can get 51% off your product. Again, that's ketowithjustice.com, 51% off, and you get a 60-day money-back guarantee. So if it doesn't work out in 2 months, just send it back, get your money back. But why not try it? Come on. So as we all know, or should know, or maybe you don't know, and I'm not trying to shame you for being ignorant, Kyle Rittenhouse on August 25th, 2020, after the Jacob Blake shooting, which led to the Jacob Blake rioting, decided that he was going to go out there and clean graffiti and provide medical aid to people on the street. He was confronted by Joseph Rosenbaum, who is a convicted felon. We're going to talk about why that might and might not be relevant later. He was chased by Rosenbaum. Rosenbaum threw a bag at him, and when cornered, Rittenhouse fired upon Rosenbaum. Then Rosenbaum ran away. He was attacked by 2 other people. He shot them both in self-defense. Pretty open and shut case, irrefutable, indisputable, it's all caught on video, and there should be nothing to talk about. However, Kyle Rittenhouse had the wrong political ideology. Kyle Rittenhouse appeared to be on the side of people who didn't support Black Lives Matter rioting. Therefore, we have this giant politically charged trial, and he has been painted by the media, by morons on the internet, and by the district attorney as this far-right extremist and a member of all these different political movements that he is not a member of. And admittedly, in this trial, or in this pre-trial hearing, the prosecution is conceding that they have no evidence of Kyle Rittenhouse being a part of any of these right-wing groups that they are alleging and trying to introduce into the trial. Which brings us to our first crucial point. Well, actually, it would bring us to our first crucial point if I didn't point out that Kyle Rittenhouse was also somebody who crossed state lines.
He drove from Illinois to Kenosha, Wisconsin. Now, again, he drove from Illinois to Wisconsin. It's not like he was in his front yard and he was approached by a group of individuals who posed an imminent threat to his life. He drove across state lines in a state that he doesn't even live in, and then he crossed state lines with it.
He crossed state lines, meaning he traveled across state lines. He traveled there from out of state.
Who again, traveled across state lines.
He's a serial state line crosser. He may have committed felony crossing of state lines. Kyle Rittenhouse was in one state, and then he moved to another state, thus crossing a state line. And then he crossed state lines. Now, the reason I bring that up is because idiots out there online, specifically idiots on the left, are obsessed with Kyle Rittenhouse crossing state lines. He drove 15 to 20 minutes from his town, Antioch, Illinois, to Kenosha, Wisconsin. Therefore, he's some kind of super felon or whatever. And even if it were true that Kyle Rittenhouse brought a gun across state lines, that in and of itself is not illegal. It wouldn't be a state crime because crimes that are committed transversing through states would become federal crimes, so this makes no sense. Also, Kyle Rittenhouse never did bring his gun across state lines. That's why he's not facing any charges in Illinois, because he would not have been able to possess the gun in Illinois. So all these idiots who are out there telling you this is like the big sign that they don't know what they're talking about, that Kyle Rittenhouse crossed state lines, are completely irrelevant and should be dismissed immediately for the buffoons that they are. But anyway, we're talking about the Proud Boys Association because the prosecution in this case has decided that they're going to go with the strategy that Kyle Rittenhouse was acting in conjunction with the so-called hate group, the Proud Boys, that he was either a member of or an affiliate of. And they've presented as evidence of this Kyle Rittenhouse going into a bar on January of 2021, which would be 4 months later, and somehow they're trying to retroactively apply that to the events in August. The judge wasn't having this. The judge said this was ridiculous.
You've been in here enough, Mr. Krause has been in here enough to know that we get these pre-sentences where the defendant is accused of any number of things, and there's a section in there about gang membership. And I have stated probably 100 times, probably more than that, that I breeze right past that because I'm not interested in these accusations about group responsibility unless it's directly connected that the defendant is active in the criminal enterprises of the organization.
And it didn't even make the minimum standard of Wisconsin's gang membership or gang association statutes. And the prosecution conceded that they have no evidence at all that Rittenhouse was working with the Proud Boys or any other right-wing militia group or hate group or any other group at all during the events of the shooting.
All right, let's assume you're bringing in the evidence about the Proud Boys being in Kenosha on the day in question and that they're here for their purposes. Is there any suggestion that they were connected in any way with the accused?
On the date of August 25th, I will acknowledge that I am not going to be able to prove that that was a coordinated thing between the defendant and the Proud Boys that night.
So they try to bring this in to smear his name, to tarnish his reputation before the jury, and the judge was not having it, and good on the judge for not having it. The second thing that the prosecution totally bungled and lost was their attempt to introduce 2 videos of Kyle Rittenhouse before the shooting that they said showed a pattern of behavior.
One is with regard to that June 1st fight. That is a fight which has been captured on video. It is an incident in which it's my understanding that the defendant's sister got into a physical altercation with another female. This was essentially a one-on-one fight, somewhat of a consensual fight. Both of them interested in assaulting one another. But in the midst of that, Mr. Rittenhouse intervenes and begins to add on to what his sister is doing to this other female by assaulting that second female.
Now, the first video involves a physical altercation with Kyle Rittenhouse and his sister. Kyle interceded in this fight on behalf of his sister and hit the girl. It's not a good look for Kyle Rittenhouse, a boy, to hit a girl. It's on video. You can check it out. I can't show it to you because of YouTube's terms of service. It would be violent and it would be talking about minors being violent, so that's something they're really sketchy about. But look it up. It's bad. There's not really good excuses for it out there online, but it's not relevant. The prosecution was trying to make the case that this shows that Kyle Rittenhouse puts himself in situations and acts with violence, just like this situation, even though they're completely dissimilar from one another.
I think if I admitted either of these, I'd get reversed. That's the bottom line. I think that the first one, the incident involving the sister, this is clear, in my estimation, it's a propensity evidence. It's an opportunity to suggest to the jurors that he's acted on in a violent way on other occasions, and therefore he acted in a violent way on this occasion. There's no connection between these 2 events at all.
So good on the judge for calling BS on that. Now, the second one is where Kyle Rittenhouse was in a car with his friend, and they were observing people looting a CVS in Chicago or in Illinois or near Chicago. Doesn't matter. I know Chicago's in Illinois for that one person in the comments who could be like, it was in Illinois. Shut up. Shut your mouth. And Kyle Rittenhouse said in the video that he wished he had his AR because then he would start shooting.
It looks like one of them has a weapon. She hung up. Bro, I wish I had my AR. I'd start shooting rounds at them.
Now, the prosecution asserts that this video proves that Kyle Rittenhouse intercedes in situations where he thinks people are breaking the law and is willing to use more than deadly force, which is beyond the standard of what you can do, even though this was in the state of Illinois, but in the state of Wisconsin. Therefore, this is a pattern of behavior. Rittenhouse wants to shoot people. He would have killed these people. This shows that he is willing to use his gun irresponsibly. Except he didn't have his gun. These are statements made well before, like 25 days or 15 days actually, before the incident in question. And he didn't shoot anybody. He didn't take any action. He didn't get outside the car. He didn't crack the window, as said over and over by the defense attorney. And the one action that he did take, which, by the way, the prosecution is trying to hold against him, is the appropriate action in this scenario. He called 911, and the prosecution says calling 911 makes him a vigilante. This is absurd. The judge determined that it was absurd.
I want to respond very briefly, Your Honor, because there is an actual action he takes at the CVS incident, and that is he does call 911 using his personal cell phone while he's watching this incident. Now, he doesn't know what's going on. He doesn't know what these people are doing. He's sitting in a car across the street. He doesn't talk to anybody. No one asks him to call 911. He thinks he sees a crime. His response, in part, is to call 911. His response is also to say, I wish I had my gun so I could shoot these people.
And the prosecution should be ashamed of themselves for suggesting in a trial that calling 911 in a previous instance and not doing anything in that previous instance that is no way similar to the current instance is somehow evidence of vigilantism. So according to the state of Wisconsin, according to these prosecutors, if you called 911 on criminals in the past, therefore you can't claim self-defense in the future. Absolutely and patently absurd. And again, it just goes to show you how weak the case is against Kyle Rittenhouse. But it gets even funnier and goofier because these prosecutors are doing everything humanly possible to try to smear Kyle. For instance, for some reason, they are obsessed with introducing the fact that Kyle Rittenhouse used his stimulus money in order to buy the gun.
He's asking it not be allowed is evidence about the fact that he used the stimulus money to buy the gun. Where's the probative value of that?
Well, Your Honor, I think it paints the picture for the jury of how this transaction occurred. How does Mr. Rittenhouse come into this money? It's a lot of money. We're not talking about $50 here. We're talking about $800 or thereabouts. So it's a large sum of money. Mr.
Actually,
Rittenhouse,
you're providing the explanation. I would think that you'd want to offer the where did he get this money? I don't understand.
We can leave the question open for the jury, Your Honor, and we can let them try and speculate if they want to. But since we already know the answer, why not tell them the truth?
I tell them anything. I mean, he had money. He certainly had a job as a lifeguard or something, I read.
I don't know that he had that job at that particular time, Your Honor. No.
I don't want to get into
Now, it is not disputed by the defense that Kyle Rittenhouse gave money to his friend who lived in Wisconsin to buy a gun on his behalf. So his friend acted as a straw purchaser for Kyle. It is also not in dispute that Kyle Rittenhouse obtained this money legally, which would be either through work, through a gift from a family member or friend, or through the stimulus check. So none of these things are in question, yet the prosecution is obsessed with telling you that Kyle Rittenhouse used his stimulus check in order to buy this gun because they're trying to smear his reputation in the mind of some of the jurors, saying that he was also misusing his stimulus check. Because even though this isn't a misuse of stimulus money, you're allowed to use your stimulus money on whatever you want. People have perceptions and ideas in their head about how this money should be spent.
I think the defense is correct that it doesn't sound to have much relevance. I also don't. You're suggesting that the reason he's trying to do it is to denigrate the defendant for not using the stimulus money for a more altruistic purpose. I would imagine that some percentage of the American people who got money used it for altruistic purposes, but I would bet most didn't, including some who probably spent it on illegal drugs.
I just don't see how it goes to any element that's in dispute here. I mean, it's just, I think it is to denigrate him, to try and paint him bad, and that's why they put it in the Washington Post article.
And if you don't understand what I'm trying to say, just think about this example. Even though you're allowed to spend your stimulus money any way you want at all, it's up to you. It's your money. You actually paid it in taxes and you're just getting it back to stimulate the economy. If somebody went to the bank, got all $1,400 from the most recent stimulus check, cashed it out into ones, and then went to a strip club and proceeded to fling that money onto the table so that the dancer could collect it, even though that's legal, even though that's what the person is allowed to do, even though it's a voluntary transaction, some people would be upset by that. And since the prosecution is not alleging that Kyle Rittenhouse obtained the gun with funds that were obtained illegally or through a criminal enterprise, the only reason they are trying to introduce this into the case is because they're trying to put an image in some of the jurors' mind that he misused the collective money or government money or money that should have went to better, more nobler purposes, because some people have that perception, just in the way that some people would react to somebody using their stimulus money at a strip club or for a prostitute or for something similar in order to stimulate the economy that way, and that's not noble enough for them. You understand where I'm going with this? That's what the prosecution is trying to do. The defense very intelligently challenged it, and it looks like they're going to win the challenge. Now, the judge said that he was going to disallow a bunch of things. There's some things that he said he was heavily leaning toward disallowing, but he will review later evidence before making that decision. But overall, this was a bloodbath for the prosecution in pre-trial. Now, they did get one win, although the reason they got the win is because this is one of the weakest points the defense tried to argue, and this is with the admittance of the criminal history of Joseph Rosenbaum.
Motion to admit evidence. That is evidence of whether, because Joseph Rosenbaum had been convicted of child sex offense and went to prison for it, I guess three different times, you can start talking with an extreme bias towards denying your request.
Now, for those of you who haven't heard, Rosenbaum, the first person shot trying to attack Kyle Rittenhouse, has a really bad criminal history. A really bad criminal history that involves 5 boys ages 9 to 12, and that certain registry that we put those oh-so-special kind of offenders on. You can read about that all you want. I will link sources and all that in the description, but I'm not going to talk about that because what we do on this channel is we talk about criminal history when it's relevant, and the specifics of the crimes that Joseph Rosenbaum committed are actually not relevant. What is relevant, or what should have been argued as relevant, is that Joseph Rosenbaum was convicted of multiple felonies, thus making him a felony prohibited possessor, meaning he cannot own or possess a firearm. Since Rosenbaum, according to even the prosecution's charging documents, attempted to disarm Kyle Rittenhouse, he chased him on video and went to disarm him, and that's what led to Kyle Rittenhouse shooting Rosenbaum. Rosenbaum should have known at the time, as a felony prohibited possessor, that he had no right to disarm Kyle Rittenhouse in that scenario. Again, he was chasing Rittenhouse. He was not under immediate serious threat, and he was doing so in what appears to be an attempt to disarm him or to hurt him or similar. So while I do agree with the judge's ruling that the specifics of the Rosenbaum crime are going to bias the jury, because when you do something that awful to 5 boys that are that young repeatedly, that's going to bias people against you. But the felony that Rosenbaum committed previously, or the fact that there was the existence of a felony, should have been represented better as the reason they're arguing for this. But for some reason, the defense said that they were going to make the argument that Rosenbaum decided then that this was his opportunity to just randomly steal a gun. Like, it had nothing to do with him trying to attack Rittenhouse overall. His actual objective was stealing the gun, which is absurd. It's a bad argument. And the judge probably ended up not admitting, or will probably end up not admitting, Rosenbaum's criminal history due to the fact that they argued this so poorly.
Mr. Rosenbaum, because of his status as a convicted felon, is unable to lawfully possess a firearm, could not purchase a firearm. He saw this as the opportunity to possess a firearm and take care of what he believed was a threat or a problem to the rioters, not demonstrators, rioters, which Mr. Rosenbaum was.
Now, reportedly, the prosecution was not very happy about being slaughtered in this evidentiary hearing. They tried to present a bunch of different things. They got struck down time after time, and the judge did not seem tolerant of their attempts to do guilt by association, even with the association being after the fact. Total failure on the prosecution, clearly showing that they don't have that strong of a case. And this is clearly a politically motivated trial because, again, they're trying to tie this to the Proud Boys and they're trying to submit a Seattle Times article as evidence that the Proud Boys are evil.
I have to tell you, I never heard of the Proud Boys before this case. And you cited a Seattle newspaper, and I'm not going to rely on a newspaper account about what an organization is, whether they're a hate-inspired group or whatever they may be.
And somehow that needs to apply to Rittenhouse because he went to a bar to have lunch and some Proud Boys were there months later. Absolutely absurd. And if you were confused about this case, there was also another motion that was really questionable presented by the prosecution, which was a motion to get the manager of Kyle Rittenhouse's Freedom Fund, you know, the fund that's paying for his attorneys, to turn over to the court a list of donors to that fund. Now, people have already been fired in this nation for supporting Kyle Rittenhouse's right to self-defense, even though his self-defense is clear and obvious and caught on video, and no rational person can make arguments against it. But they want the names of the people who saw the video, were moved by this, think that the prosecution is unjustified, just so that they can publish them publicly in order for them to receive a bunch of attacks.
Motion to compel discovery about donation lists, and is this still an issue?
It is.
Okay. Now, the defense statement by Mr. Richards that I read was that he doesn't have any access to any information from Free Kyle USA. And are you disputing that?
It's run by the defendant's mother, so yes, I am.
It is.
The defendant's mother is not a party to this action.
Well, the defendant's mother is someone who the defendant can obtain information from quite easily.
Legally?
Your Honor, this is not a third party. This is not an accountant.
It is a third party.
It's his mother, Your Honor. I submit that it's a reasonable request of the defendant. He's the beneficiary of all of that fundraising. He is the person. It is called Free Kyle USA. He's Kyle. So this is not an independent entity. This is something that they have the ability to access. And Your Honor, quite honestly, if the shoe were on the other foot and there was some sort of fundraising for the state in this prosecution and we didn't turn that information over, it would be per se reversible error. So we're entitled to the same.
I'm telling you, by what authority can I order a citizen to provide, that you can subpoena, by the way, to provide material to the defense attorney or to the defendant that is her proprietary information and command them to cough it up? The law is I can make them produce what they have. I cannot compel them to produce something, nor do I know of any authority that I can make her give it to them.
And what's even more insane about this is that Kyle Rittenhouse isn't even the manager of the fund. So they were asking the judge to get a third party who happens to be Kyle Rittenhouse's mother, which legally does not matter. It's a third party not related to this trial, to turn over all of this information so that they can publish it publicly so that the people who donated to the Freedom Fund can be socially ostracized and punished politically by the media for doing so. It's absolutely shameful. It's absolutely disgusting. You have a right to a defense in the United States of America, and who donates to you, again, after the fact, in order for you to have a good defense, should have no bearing on your guilt or innocence. This is totally irrelevant information, and the prosecution apparently has the power to try to subpoena this, so this actually might get published for public consumption, even though, again, this would be guilt by association after the fact in order to say that Kyle Rittenhouse didn't have a legitimate case of self-defense. Now, setting aside all the things that I went over before that I believe to be an element of prosecutorial misconduct or the prosecutor abusing their powers in order to smear their client and smear people who donated to their client, there was also an interesting revelation in this pretrial hearing about FBI drone surveillance video that's in infrared that supposedly shows Kyle Rittenhouse being the aggressor against Rosenbaum. And supposedly this video that we have not seen is a bombshell that will destroy the defense showing Rittenhouse was the aggressor. However, this video likely will not show that, and the reason why is because we have video of Kyle Rittenhouse running into a gas station to get a fire extinguisher, running past Rosenbaum to put out a fire, and then being chased by Joseph Rosenbaum. And on top of that, if there is any other video that shows Kyle Rittenhouse initially instigating an issue with Rosenbaum, which I do not believe this video will actually show that clearly, that doesn't matter under Wisconsin law, which we've gone over before, but I will highlight this portion of the self-defense law to make this abundantly clear to you. So for some reason, the media keeps asserting that Kyle Rittenhouse is not protected by the Castle Doctrine, and yeah, while this is true, the Castle Doctrine doesn't apply here. They're alleging that Kyle Rittenhouse provoked the attack either through legal or illegal conduct. Now, specifically in this case, it is through illegal conduct. And due to the fact that a lot of people are legal laymen, they assume that if you do something illegal and that creates a situation where you're attacked, under no circumstances can you claim self-defense later if you fight back. However, that is not the case under Wisconsin law. If you go to their self-defense statute, go to section 2A and 2B, which I will read for you, it makes it clear what the circumstance is. Even if you're initially in the wrong, you are able to still claim self-defense. And tell me if they sound familiar. 2A, a person who engages in unlawful conduct of a type likely to provoke others to attack him or her, and thereby does provoke the attack, is not entitled to claim the privilege of self-defense against such an attack, except when the attack which ensues is of a type causing the person engaging in the unlawful conduct to reasonably believe that he or she is in imminent danger of death or great bodily harm. In such a case, the person engaging in the unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to the use of force intended or likely to cause death to the person's assailant unless the person reasonably believes he or she has exhausted every other reasonable means of escape from or otherwise avoid death or great bodily harm at the hands of his or her assailant. So what Section A clearly means is that if you're committing a crime and that crime instigates a situation where somebody attacks you, you do not have the same exact self-defense protections as a normal person in the state of Wisconsin. In this scenario, in order for you to be able to use force that can cause death or serious bodily harm, you must first exhaust all the reasonable options of escape. Kyle Rittenhouse was trying to escape from Joseph Rosenbaum just before the shooting. It is indisputable. Apparently, according to the defense, drone footage will show that once Kyle Rittenhouse was at that point in the car dealership, he had no way to run any further. This is totally within the definition of Wisconsin state statute. So even if they show Kyle Rittenhouse allegedly provoking some kind of an incident with Joseph Rosenbaum, which I don't believe, he still tried to flee the location, which is him exhausting his options to escape when things got dicey. He didn't just provoke him and then shoot him. That's not what happened. And Rosenbaum is not within his rights at all to chase down an armed individual to attempt to disarm him because they had a disagreement that provoked him. That's absolutely absurd and does not stand up under Wisconsin law. Also, again, take note of this because the second shooting of Huber and Grosich, Kyle Rittenhouse was also running away, and then they instigated an attack on him, and he only shot when he was on the ground, and he shot the minimum amount of shots to get himself out of each scenario. So the prosecution has no case at all under Wisconsin self-defense law, and if that wasn't clear enough, let's go to Section 2B. Privilege lost by provocation may be regained if the actor in good faith withdraws from the fight and gives adequate notice thereof to his or her assailant. So Section 2B is also quite clear and shorter, so easier to understand. And what this says is that if you provoke a fight and that leads to a situation where you're in danger, you have to disengage in a good faith way from the fight and provide adequate notice that you're doing that under Section B. Kyle Rittenhouse running away from Rosenbaum is him in a good faith way trying to escape from the fight. Him running away and not shooting him with his gun is the good faith notice that he is intending to not shoot him with his gun unless he is pursued. Again, Rittenhouse is perfectly covered under either one of these because if somebody is running away from you and they have the means to kill you readily available, and you can see that, a reasonable person would assume that they're trying to disengage from the fight, not trying to engage in the fight. It's absolutely absurd to argue anything to the contrary, which means that even if the FBI has the absolute bestest infrared video ever, it is not likely to change what we know about the case because the case is completely open and shut. And by the way, Rosenbaum did reach for the gun. The witness, McGinnis, who's the guy who took off his shirt to try to render aid to Rosenbaum, said that he went for the gun 2 times and that caused Rittenhouse to shoot him. Totally justified under Kyle Rittenhouse's point of view and by Wisconsin state law. If somebody goes for your gun, it's the most obvious thing on you, then you have to assume and you have a moral obligation to not let them do that because the assumption is that they are going to use that gun to harm you or somebody else. He had an obligation to defend himself, just like he had an obligation to run from the situation and not try to start a deadly fight when it wasn't necessary. He met both of those obligations, therefore this is self-defense. Clearly and obviously. I mean, in the second shooting, they're literally attacking him, so we saw what happened when he lets them get close enough to attack him. They actually attack him, and one of them has a gun and reportedly said that he wanted to shoot him. Kyle Rittenhouse was just too quick for him and too accurate for him, so he didn't get the chance to murder him. This is a clear and obvious case of self-defense. It's covered under Wisconsin law. No FBI drone footage is going to change that. This is why lefties have to make this ridiculous scenario where Kyle Rittenhouse supposedly said, hey, I'm going to run into that parking lot and kill you. Joseph Rosenbaum, who I guess is Batman in this scenario, was the only person who heard it, so he chased after him in order to save everybody from Kyle Rittenhouse. It's absolutely absurd. Kyle Rittenhouse had multiple different opportunities to kill people in a premeditated way, and when it got to a situation where he thought he was in danger, his first instinct was to run away, not use his self-defense weapon to kill somebody. So to be clear, there's absolutely no case here. It's an open and shut textbook example of self-defense, and it's caught on video. What the prosecution is trying to do is a politically motivated prosecution because the left doesn't like Kyle Rittenhouse. You don't see them calling on the FBI to get drone footage of all the rioters that destroyed Kenosha that night. They're not interested in that. You see them using the FBI in order to get some kind of infrared thing so that they can try to put it out there in the public that they got Rittenhouse dead to rights. You see them going after Rittenhouse's donors because they're trying to cut him off from financial resources so they can bury him in legal fees. You see them trying to bring up completely irrelevant, completely different, unrelated instances in order to show a pattern of behavior that is just not present in any of the things that they've presented. Kyle Rittenhouse is innocent. He acted in self-defense. If you don't get this, then you don't know anything about the case, or you're so politically biased that you're basically incapable of thinking for yourself. But hey, those are just my thoughts. Let me know your thoughts down in the comments below. If you disagree with me, that's where you should leave your wrong opinion and label it so I can skip over it without getting into your nonsense. If you liked the video, then show me by leaving a like, subscribe for more content, follow me on all my social media, support me via the support links in the description box. This has been me talking about the Kyle Rittenhouse pretrial stuff. Till next time.